You may know what a will is. It's either called a will or a last will or a last will and testament. That's what we hear on the street. These are the common terms. You may have one, but chances are you may not have one. Now, if you're at a webinar like this, you may be more interested in estate planning and you already have a will in place. However, the statistics are 50% of all people pass away without a will. A will is a legal written document that names your beneficiaries, who gets what. I love to say that, who gets what, who gets the items within your estate, and when and how. So you can give a specific request. Upon my passing, I want the sum of $10,000 to go to Salvation Army. I want the sum of $10,000 to go to Shriners Children's Hospital. Right? I want $10,000 to go to my niece. I want $4,000 to go to my nephew. We never liked him anyway. Or I want some money to go to the ASPCA. Now, if you have money in a bank account or a brokerage account, that can be easily handled. If you have a home, a piece of property that needs to be sold, the house or property would need to be sold first, and then the specific request from the proceeds of the sale would be attended to by your executor, administrator, or trustee. Now, you may think that you're protected with a simple will, but and you could be protected. The circumstances are, the fact is, when you have a will, your estate must go through probate. The will, if valid, perfectly executed, nicely crafted, a gem in all respects. It's a document that needs to be brought to court with a petition with a filing fee. So it can be great if you have a simple circumstance and you want to give maybe some bequests and divide things somewhat evenly. A will can be great. I have a different slide with some of the downsides of probate, but just factually, a will only controls what you own in your name. So I gave a prior example of owning a piece of property jointly held, so a husband and wife, or brothers, or siblings. If you own a piece of property with someone else as a joint tenancy ownership, the survivor of the two people receives that property. So even if I put in my will, I want the property located at 123 Main Street to go to my 3 children. By operation of law, if I own the property jointly, it will go to the survivor. The will clause that says it will go to my children is ineffective. It won't be able to handle that circumstance because the property was not owned by me individually. So another item is a will, a last will and testament. Even if properly executed and valid, it is only used upon death. If I make a will today and I don't pass away for 50 years, I should be so lucky. If I don't pass away for 50 years, that will can be perfectly valid for the entirety of that time, but it has no present day force and effect. It is a great document that is inactive. It can only be activated upon my death and upon filing of a petition in the surrogate's court. It doesn't control jointly held assets or even assets with beneficiary designations. So if I have a bank account and it says in trust for my 3 children, if I had any sum of money, $1 million in that bank account, and I want to give to the Shriners Children's Hospital and Long Island Jewish and the ASPCA, none of those charitable organizations would get any money because in my example, it was in trust for my 3 children. By operation of law, at my passing, it goes to them. They just have to produce a death certificate.